Some municipalities use, it's an olfactory sensor that they use in order to determine whether or not there's enough particulates in the air to set off the meter if odor is a physical issue or not. That's something that we are considering as part of that odor control bylaw, but for the time being it will be, it'll just be whether or not the odor is present, and if it is, then enforcement will follow.
So you're saying there is a meter that's available to detect that?
Yeah, through the mayor, that's correct. The correct terminology for that, I believe, is called a nasal ranger.
Okay. My last question, have Health Canada participated in setting up these recommendations? Or have they been involved in the process?
Through the mayor, they have. They joined our cannabis task force a couple meetings ago. They've been involved and have had a chance to review our proposed policy. It has been nice to have them around the table and actively involved in our process. Thank you.
Thank you. Councillor Black.
Mayor Luke, thank you very much. And I guess if anybody was listening to the radio or TV or media this week, it was pretty close. The Senate just about voted it down, I guess. And I think some people are sitting on pins and needles waiting for the Senate's decision. But Mayor Luke, I would like to thank staff who have reacted so quickly with this issue. I mean, it's all of a sudden it just seemed to pop up, and so many of the rural people are being affected by this. So thank you very much for coming forward with all of this information, which I completely support. But my question, one of my questions is about the Part 1, Part 2. Like you said, you know, there is no problem with the Part 1. So why do we have a Part 2? Why can't the Part 2 be as regulated as the Part 1? Do we have any say in that? Can that happen? And then we wouldn't have some of the problems with the odor and with the light pollution or security.
Through the mayor, it's really a matter of how the federal regulation works, how the ACMPR works around those two different forms of facilities. But to answer your question, the proposed bylaw in front of council is doing exactly what you're suggesting. It is putting them both on the same playing field. It is not, and it's staff's position that it is not limiting access. It is giving options to self-regulate your odor emissions. If you choose to self-regulate your odor emissions, similar to the Part 1 facilities, then you have a similar setback as what a Part 1 facility would have. If you choose not to, then it's proposed to have a larger setback.
Okay, well that's good news then. That's what it's been up to your staff and the municipality to do that regulation versus, you know, the federal government. That's unfortunate. Secondly, I'm getting lots of calls now. People are understanding some of the things that can occur, like the growing of 4 plants per home, per apartment, per condominium. How will that be regulated? Is that from above, or will that be up to the municipalities to regulate and enforce? Mr. Anslin over there, will he require more staff to do that? Will it cost the municipality? Who pays for that? Do we have any answers for that?
Through you, Mr. Mayor, the proposed bylaw and the report is actually not addressing the proposed 4 plants per household. That's how they've defined it, as a per household. The Health Canada has not really defined what household is, so right now it's fairly open. It could mean single detached dwelling, it could mean apartment. We are not proposing to regulate it. From my opinion, it would be very challenging to enforce, very challenging to enforce. And the federal government, I'm not sure whether or not they would be in a position to regulate that either.
Okay, and then lastly, I'm getting calls from people, apartments, condominiums, townhouses, houses that are in close proximity to one another and already are experiencing odor from people smoking marijuana, maybe sometimes in their house where it's going through walls, it's being able to pass through, or even outside, and it, blows in through windows and open doors. So will there be some sort of regulation at the municipal level for that type of odor?
Through you, Mr. Mayor, at the present time, we are not proposing any control or regulation in regards to the smoking of marijuana. My understanding is that the odors, the actual use of marijuana is going to be treated very similar to tobacco products, in that it will not be allowed to be smoked in certain places like public parks or municipal buildings and that sort of thing. People will be able to smoke it on their within their house, within their yard, on their own property. But I understand the recreational use will not be permitted in the public space. However, there is also the medical licensed use of marijuana as well. And so that's where it gets a little bit of into a bit of a gray area, because those people who hold a card or a prescription to use marijuana for medical purposes are permitted to use it in public spaces. So the regulation from an enforcement or OPP perspective is going to be very difficult in that respect.
Huge can of worms. And lastly, Mr. Mayor, I did hear on the radio and listen to a councillor from Hampstead, Quebec, where that council has put in place a bylaw banning the smoking of marijuana in any public place, parks or sidewalks or public buildings or anywhere. So that was quite interesting.
Councillor Oliver.
Thank you very much, Mr. Mayor. I apologize to staff for having my back turned to them, but I want to be able to refer to my report. Matt, my first question relates to the setbacks, and I'm looking at page 4 of the report, that whole section, paragraph A through I guess, and where we talk about no lands, building, or structure, or portion thereof, et cetera, can be located closer than whatever the setback is. So if there was a scenario where there is a greenhouse located on a parcel of property, which would apply, within the greenhouse or on the property on which the greenhouse is located in terms of the setback? In other words, is it from property line to property line in the case of paragraph A, or is it from a building within which the marijuana is being grown or produced to a property line?
Through the mayor, it depends on which zone it's in. So, for instance, in the industrial zones, it uses both property line and the use, so the adjacent building. In both cases, it's from the facility in the industrial zone, so 70 meters from the facility to an adjacent residential zone or sensitive land use zone, and from the facility to an adjacent sensitive land use. So let's say there's a residential dwelling and it's in an adjacent industrial zone. It would be from the facility that's growing cannabis to that adjacent residential dwelling or something like that. So in the industrial zone, it covers both of those. In the agricultural zone, it's just from the facility to a sensitive land use. So it's from facility, building to building.
Right. Okay, thank you for that clarification. My second one relates to the matter of enforcement, and I did ask Matt this question previously, and I'll ask it again for the benefit of the public that are here. We're going to enforce these bylaw provisions based on complaints, and have staff decided, so to speak, if a single call is received from a neighbor that is being subjected to odors from a facility in which marijuana may or may not be getting grown or processed, will the anecdotal evidence given by a complainant be sufficient to trigger enforcement? And part of why I'm asking the question, Mr. Mayor, I'm thinking of our of our noise control bylaw, where it has become quite technical, and there has to be documentation over a period of time, et cetera, before bylaw feels they're in a position to actively enforce. So that's my second question. Will a single call from a neighbor who has anecdotally told us that they have experienced odor problems trigger enforcement?
Through you, Mr. Mayor, and I appreciate the opportunity to answer that question. We would certainly enforce that similar to our other bylaws. Written complaints is what we look for, only because if the matter does go through the legal process, we need to have some backup evidence and information. So we would not take it as an anonymous complaint as usual. We would ask that the complainant be specific, their location, and the details of the complaint. And then our enforcement staff will go and proceed with an investigation, site inspection and evidence gathering, and then determine whether a violation is taking place or not.
But if thanks, Fritz, if a neighbor calls and makes a complaint by phone, am I not correct in assuming that an officer would at least get their information over the phone and do a site visit? You're not going to require a written complaint before an officer will even do a visit, will you?
Through you, Mr. Mayor, it's been our practice and our policy to request for written complaints. Now, however, if there's a safety issue or a health and safety matter that needs to be investigated, we will proceed without that. But on a complaint on a zoning bylaw or any other bylaw matter, we will request that a written complaint be submitted.
Okay, and my final question also, I guess, then to Mr. Insland, is assuming a neighbor is concerned enough, or multiple neighbors, that a written complaint is made, do our bylaw staff, or will our bylaw staff have the authority to go and visit a property on which we think marijuana is being grown or processed and inspect the premises? In other words, go inside a greenhouse to determine if in fact marijuana is being grown. Is that something we can or will do?
Through you again, Mr. Mayor, we can attend a property. However, we do make the owner aware that we're there as best we can, so that there's no reason for it to be suspicious why we're there. So we do notify the owner as best we can. If there's no contact with the owner, the bylaw officer can investigate the property. However, the only restriction is we don't have entry rights to any dwelling. So the dwellings would be prohibited. We probably would not go into a greenhouse for various reasons due to contamination of any disease, spreading disease or anything like that, same with livestock. So we would probably stay out of the greenhouses for that purpose so that there's no contamination risk for the greenhouse.
But I can certainly appreciate where we wouldn't go in without notifying the owner that we're coming because we've received a complaint, et cetera. But how would you be able to determine if marijuana is being produced if you don't go inside the greenhouse, with the owner's permission, presumably?
Through you, Mr. Mayor, that's the challenge. Certainly,
is.
we have restrictions. We can't just enter into any building or property. If the owner really doesn't want us in the building, we're certainly not going to press our way in. I mean, we have certainly respect for the person's property, and we would then likely either find other ways to investigate, whether there's other evidence from neighbors, testimony, from evidence around the building, photographs. There might even be an opportunity to get a search warrant if necessary. But
Councillor Oliver, CAO Cribbs wants to
Okay.
speak.
Thank you.
Just in response?
Yep. That's going to be a big issue, though, Mr. Mayor.
Yes.
Well, if the topic's done, we're good now. I don't think we should go too much further into our anticipated enforcement strategy and mechanisms for a wide variety of good reasons.
Thank you. Councillor Height, please.
Thank you, Mayor Luke. Through you to planning. Matt, how did you determine the setback, the 150 meter setback?
Through you, Mr. Mayor, just clarification, are you referring to the 300-meter setback or the 150-meter setback?
150.
Through the mayor, the 150-meter setback was established by council during the initial bylaw, the medical marijuana production facility bylaw, and that was back in 2014.
Okay, did I not see on this presentation it was 70 in industrial at one point in time?
Yes.
All right.
Through the mayor, that's correct.
Okay. So, like that takes out a fairly large chunk, I guess, of industrial property that would say butt up against a dwelling?
Through you, Mr. Mayor, I'm not exactly certain about how much property it would take out, but it would be more limiting than we have today.
Okay, thank you for that. Now, we touched upon it earlier, a Tier 2 grower, I guess. You mentioned that you think that they would be grandfathered site by site?
Through you, Mr. Mayor, it would be a site-specific analysis of whether or not the facility or site would be grandfathered.
And how would that get triggered?
It would, through you, Mr. Mayor, it would start with a complaint. We would require the owner to prove their existence ahead of the bylaw in 2014. And we'd need to investigate a little further because prior to 2014, the use didn't exist in our zoning bylaw. So there would need to be some evidence that the use was permitted ahead of that bylaw. So a legal non-conforming use may be challenging to prove.
Okay, and I also understand it'll be under site plan control. How does that get triggered? Would there be a complaint and then that would trigger you to put them under site plan control?
Through you, Mr. Mayor, the trigger of site plan control preferably would go through the proper channels, would go through our pre-consultation process, an application if it's necessary for zoning, if that's what I mean. If zoning's not necessary, then the site plan application would go through that pre-consultation, it'd be submitted, it'd go through that regular process. In the event of an existing facility, the way the bylaw reads currently is that it's if the use is established or added or anything like that, then that would trigger the site plan process. So if there's an existing facility out there today and they're not in compliance, in order to come into compliance, they'd have to go through our site plan process.
So just so I'm really clear, Mr. Mayor, through you to Matt, a bunch of these site plan control issues could come online all at one time.
Through you, Mr. Mayor, I'm not sure they would come on all at once. Like I said earlier, we're not going to be actively policing the issue. This is a complaint basis, so I would anticipate they may trickle in.
Okay, and there's a 4 to 5 month lead time on site plans, is that correct?
Through you, Mr. Mayor, that's correct.
Okay. Yeah, that's a bit of a dilemma. All right, thank you.
Thank you. Matt, question I have, and I want to preface it because it's about legal non-conforming, which I've had a lot of inquiries about lately. And I did a little homework and I went back through our bylaws. And Matt, on June the 17th, 2014, almost 4 years ago, was when the former mayor and the former clerk signed the bylaw regulating marijuana. And in the bylaw, of course, 70 meters was determined at that time for setback in industrial and 150 meters in agriculture, as you've said. And they were all incorporated and put into the 4 zoning bylaws of the day. Former Nanticoke, former Simcoe, former Delhi, and Norfolk. So this whole idea of legal non-conforming, it would seem to me that another requirement of the setbacks, 70 and 150 meters respectively, would be site plan control. Is that correct?
Through you, Mr. Mayor, that's correct.
So Matt, is it fair to say that until the 4 plants of 1 meter in height per household, which is supposed to come in effect July 2nd of this year, but more likely will be September, don't know. Is it fair to say, notwithstanding that all marijuana operations in this county and anywhere in the province require some sort of permission/application, correct?
Through you, Mr. Mayor, that's generally correct. Again, we would look at it on a site-by-site basis to see whether or not they would be deemed to be legal non-conforming, but as I said, it'd be challenging to have that status.
If I may, my question to you is if you have an operation and you've either got a letter from your family physician, thus apply for your application for whether it's 24, 50, 74, 90-some plants or whatever, depending on what your doctor prescribes, it would seem to me that if your letter is dated prior to June 17th, 2014, or your license has been approved prior to that, then you'd be legal non-conforming. If it's after that date, how could it be legal non-conforming? If the bylaw is in effect and you haven't had your application or approval signed, is that a fair way that I'm looking at it? And I know we have our legal counsel here. Folks, if you don't know this gentleman, this is Nicholas Loeb, is our new county solicitor. Did you wish to speak to this?
Yes, Mr. Mayor.
It's a pretty important issue, I think.
So the timing of when a federal Health Canada license is issued to a person for personal growth or designated person growth would not necessarily impact on a legal non-conforming use analysis. So the answer is no, those two things don't necessarily interact.
So you could be doing something without a license prior to June 17th and still be legal non-conforming. That's what you're telling me, the way I understand what you're saying. Could be.
The AMCPR contemplates a person obtaining a license or a registration, or the two terms under it, and from there, they wouldn't necessarily have to operate and therefore have a use of a medical marijuana facility immediately. There's no significance of the timing of when the license is issued.
It's the date of starting to cultivate and process.
In the general context, legal non-conforming use, the relevant date is when a use is established.
When the use is established, not based on the date of the application.
That's correct.
Thank you. I needed to have that answer for some of the inquiries. That's all I have, Matt. Anything further to staff? I see Geisens and Brunton.
Mr. Mayor, I think I did tell you that I have to leave, but I want to thank our planning staff for what they put together. We've certainly had a lot of that, and I realize I don't have a question if you'll let me take that. I mean, there's a lot of people out there who are very, I guess, not very happy is the best way to put it that I can. And I'm hoping that what we have here will actually do something and make it at least a lot better than it is now. And unfortunately, I do have to leave, and I hope that Council will pass these recommendations. So thank you very much.
Thank you. Councillor Brunton, please.
Thank you, Mayor Luke. Two questions. One, and I'm not sure who might answer this.
Well, to get it out on the floor, we'll see if somebody can answer it.
The issue we dealt with a week ago in camera, if we pass this particular report, will it address that issue in suffice?
I can't even give an answer to that qualified question in this context and forum. If you want to go back in closed session to revisit any issue we've dealt with previously, we can do that by way of motion. But the fact that we ask questions and then give answers gives rise to an implication in front of the Information and Privacy Commission that the whole thing should be released. So we can't even give you like a nuanced, subtle answer to that question. So, sorry, I'm not trying to jam you up, but the whole point of having meetings there's some sensitive matters that can't be, at this point in time, released to the public, and giving that answer implies that some part of it should be released, and is a positive inference is drawn by the IPC when they examine that. So if we could have a different question, that would be ideal.
I was just looking for a simple yes or no. We can't give that, eh? Thank you. My next question is, I'm looking at this letter from the South Coast Wineries and Growers Association. I guess my question through you to Matt. It says in here, these operations, the marijuana, cannabis growing facilities, greenhouses, should be omitted from allowing this to take place on the Lakeshore Special Policy Area. Is that being addressed, or is that a concern?
Through you, Mr. Mayor, the bylaw that's before council is county-wide, so it would include that area as well.
It will. Okay. Will somebody inform that group if it is passed?
Sorry, let me rephrase that. I believe the letter is saying prohibit outright in that area.
Be omitted.
Omitted, so prohibit, omit. The bylaw that's before council will not address that concern explicitly, because it would still permit it in agricultural and in industrial zones with certain setbacks. So the bylaw before council today does not address that.
Thank you.
However, if council chooses to address that, that would be up to them.
Well, that's a good question. I'm not sure. I'm just relaying the concern in the letter. Was it considered by your committee?
Through you, Mr. Mayor, the letter was only received, I think, in the last day or two.
Okay.
So it has not been contemplated at this time, but it's something that council can consider.
Do you think it should be?
Through you, Mr. Mayor, I haven't had time to consider it, so I'm not certain.
Thank you.
Further questions for staff? Councillor Oliver?
Thank you, Mr. Mayor. Just on that last point, even if council goes ahead and approves the recommendations in the report this evening, am I correct in thinking we could, at a subsequent date, choose to implement a change in permitted uses within a certain area, i.e. the Lakeshore Special Policy Area, should we choose to do so at some later date?
Through you, Mr. Mayor, that's correct. If council wishes for planning staff to come back at a later date to address that, that's something that we could do.
Anything further? Okay, I would like at this time to invite anyone that's in attendance this evening who wishes to speak in favor of the amendments to come forward and speak at this podium, and we have a book there and a pen, if we could get your name and address for the record. If you put your hand up, I see one here. Team? Excuse me.
Greg and Laura France, here to talk. Bear with me, I'm losing my voice, which is a pretty inopportune time. But first and foremost, I just want to say that this is not about cannabis. This is not about for or against marijuana. This is about being able to enjoy the use of your property, be able to go out outside, be able to open your windows, be able to use your dryer without pulling your clothes, live in your own home, in regards to facilities next to you that are causing trouble. I just want to put a quote out here from the Environmental Protection Act. An adverse effect is defined or experiencing one or more of the following while on your property, and I pulled out a few of these. Harm or material discomfort to any person, an adverse effect to the health of any person, interference with the normal use of your property, or interference with the normal conduct of business. And I think I can speak for many people, both in our current location as well as locations around the county, that this is being adversely affected. I can also say in conversations through the Ministry of Environment, who currently have no authority to act on this, from our location alone, and this is as about a month ago, they've received over 150 complaints on just our particular property. I cannot speak to other properties, but this is and they said they have received ones from multiple other properties around the county with this adverse effect. I do also want to say, and I think everyone here has done a very good job of conveying this, this is not about your 4 plants per household come July 2nd or September, or whatever it may be. I do see that a lot. I make the mistake of looking on social media, and I see that as seeing what's being attacked here, and that's, first of all, there's no attack, but being regulated here, that is not being regulated. Also, I want to call out that, for Joe Smith or whoever that is minding their own business, growing a small amount of medicinal plants, not causing any adverse effects to neighbors, as this is on a complaint basis, this is not going to disrupt you. You've got your 6 plants in your basement, you've got your license for, you're not affecting the neighbors. This is all about folks that are taking, well, that's my opinion, I'm not going to say it, who are utilizing the systems provided by the government to grow thousands of plants, hundreds to thousands of plants for 4 people. And I want to make this clear, this is for 4 people. These designated grows can grow up to 4 people's worth of plants. I'm not here to debate whether that much marijuana is warranted for any prescription. That is not what this is about. But I want to make it clear that this is about that. And these folks that are growing commercial scale operations under the guise of a personal designated grow. So again, the sheer quantity here is akin to a commercial grow like a mayor can. So that's what this is about. I just really want to make that clear. And I've heard Mayor Luke say this before, as well as other councillors. I mean, nobody here is against marijuana. Nobody here thinks it's a bad thing for the county. This is about controlling and regulating a substance that is causing adverse effects to neighbors. So I just want to start by saying that, and thank you for bearing with me while I went through my notes. Yes, this is about, having the same regulations that are already in place for those same size commercial grows. I mean, this is not asking for anything different than what these commercial growers, these guys that are following the rules like the mayor can, are doing. So I just wanted to throw that out there because I do see a lot of maybe uninformed rhetoric out there that argue to the contrary. I just want to also throw out a few misconceptions or debatable facts. Again, these personal designated grows in questions are small. Well, this was what was designed, I think, when Health Canada made the rule. Per the Health Canada website, the current average amount for a marijuana grower or a marijuana prescription person getting the prescription is less than 3 grams per day. This equates, according to the calculator, to 5 to 15 plants per person inside, or 2 to 6 outside grow. This is not what we are seeing here spring up around the county. We are seeing people, again, growing up to thousands of plants. The specific operation near us was busted for illegally, no licenses, growing 5,000 plants in their facility a few months before Health Canada, actually probably a few weeks before Health Canada decided to grow them a license. They were busted by the police, no license, and the newspaper said 5,000 plants. So I know that facility across the road hosts 5,000, could host 5,000 plants. I'm not saying they do right now. I'm not going to make a claim like that, but I'm saying that greenhouse could and has held that many. And I can also say, in my opinion, that the smell coming from that property is just as bad, if not worse, as when they were illegally growing it. So I want to call that out. Another misconception or debatable fact I've heard about is that this is just the same as any agricultural crop, and you can just get used to the smell. I cannot disagree with that more. I've grown up on the same road where I'm living now my entire life. It's in an agricultural area. I've smelled manure, I've smelled pesticides. There's a chicken farm not nearby. It smells like chicken poop every once in a while, but it comes and it goes. And it's just part of rural living. My wife has grown up on a tobacco farm. She's dealt with sucker sprays, tobacco like that, same thing. This is not anywhere near the level of smell. These things go away, they're short term, and I've never smelled anything like that inside my house. My vehicles smell like marijuana. I go to take my son to skating, I go to the arena, I go inside, I come out, step in my car, it smells like marijuana. My dryer smells like marijuana. I have to wake up in the middle of the night when the dryer's done, rather than leaving it to the next morning to take it out, run down and pull the clothes out in hopes that the dryer sheet smell is still overwhelmed with marijuana. throw it on the floor, go back to bed. That is the kind of thing we're dealing with here. I cannot take my children outside in this kind of weather. I get a headache. When I snow blowing my driveway, you'd think in the middle of the winter this wouldn't be as bad. Snow blowing my driveway, I'm sitting there, I'm getting a headache. I couldn't eat supper afterwards. This is not a typical agricultural smell, period. As an interesting aside, I am curious, and this is not a discussion here, but how come this does continue to go along year-long after a prescription has been fulfilled? Why are they growing more? I know that's something we can deal with here, but it's just an interesting thing that I've noticed. Another thing I want to call out, which I think I've kind of done to death in this last couple, is that this is helping so many people get their medications. So again, this is absolutely true when it comes to places like Marican. They're probably growing for hundreds of people. When it comes to these places across the road, literally 4 people. 4 people is the most you can do. So, when we're talking about, it's, and again, this is not a debate about the merits of marijuana. I do believe there's a lot of great merits as far as prescriptions and making people feel better. I also want to call out where we're creating lots of legal jobs. I remember one of the councillors on the previous meeting asked that question in January. Per the ACMPR Part 2, Section 188.1, if an adult registered person who is a designated producer, they can also participate in the activities, in all the activities of the designated person is designated to contact. So in short, only the grower of the marijuana or the personal designated grower can touch the marijuana. So nobody else in there can touch the marijuana or be involved in the processing or cultivation of it. I'm not seeing where this is happening inside or outside, but I do want to call out as far as jobs, there's only 4 people plus the 4 growers themselves that can actually touch the marijuana. So that's something I really want to be clear on as well. Helping the local economy, again, I think a place like Marican is absolutely helping the local economy, taxes, jobs being created. Currently, it looks like that's starting to change with the personal designated grows. There's no permits, there's no business license being required. I would question, and I could be proven wrong here, but I would question how this is helping the economy or where this money is going from the personal designated grows. Another one, I've seen is, just sue them. Take them to court civilly, right? I've got some information for anybody that feels that way. And I do believe it is a potential avenue for sure, but lawsuits are extremely expensive. We're talking tens of thousands of dollars to do something like that with no guarantee that you're going to get anywhere, with often retainers paid up front. I do also want to call out that per the advice of Health Canada, right on the Health Canada website, municipalities may choose to enact bylaws which deal with odors emanating from personal production sites. So that is something actually recommended by Health Canada as well, which you guys are proactively doing right now and voting on. That is at the end of the day, my question is, why should 4 people's rights to grow copious amounts of cannabis interfere with my rights, my children's rights, my neighbors' rights to be able to just use their property? The smell is akin to a skunk, several skunks going off pretty much 24/7. We're at the mercy of the wind, what direction it's going. I'd like to just turn over to my wife, Laura, to speak to a bit of our story.
I am here in front of council to share my family's experiences living next to a Part 2 facility or a medical marijuana designated super grower. When our neighbor's marijuana grow up was shut down June 2017 and 5,000 illegal plants confiscated and the resulting arrest of 7 people from that property, we thought the nightmare that we had been living for the last several months was finally over. Sadly, within a month, operation was back up and running on an equal scale, only this time it was clear that legal licenses from Health Canada had been obtained. To make matters worse, additional civic addresses had been obtained, which would allow the property to grow up to 20 registrants in this one greenhouse. This greenhouse, with 0 air filtration, is 8 meters from the closest dwelling and around 20 meters from our home. It consists of a 5-acre property with several large greenhouses that take up the majority of that acreage, a home, and a small outbuilding. When they were busted for 5,000 plants, that's equal or even more to what places like American are producing. So just keep that in mind. The production of medical marijuana at this property is extremely large scale. This isn't 50 plants. This isn't, oh, it's 100 plants that you have to deal with. We're talking about hundreds and thousands of plants, 24/7, 365 days a year. It's also grown on a rotational basis, so a new portion of the crop is maturing, for all parts of the year, and it is putrid. There are times in the day that the wind directions give us a bit of a reprieve, but it's safe to say we are plagued by the smell nearly every day. We are prisoner in our own home and on our property 24/7. The smell penetrating into our home is noxious. At the worst of times, we had to cover all of our furniture and move from our home that we work to pay for into our in-laws' basement. For over a month, because we could no longer stand the adverse physical effects from the obnoxious odors coming from our neighbor's property into our home. It is heartbreaking to have to hear your 4- and 2-year-old children coughing and gagging every night from odors coming into their own bedrooms. During the extremely bad nights before we were forced to move out of our home, my children would refuse food the next morning. And if they felt anything like I did, likely it was feeling too nauseous to eat. After several attempts to remain in our home and having to evacuate in the middle of the night due to odor, we finally gave up and moved in with my husband's parents. The nightmare continued because even farther up the road, we were not safe from the odor coming from the marijuana greenhouse. There was absolutely no escape. Aside from being nauseous, I myself have suffered other adverse health effects from living beside something so noxious. I suffered 21 migraines in the month of September alone. There were days that I had to pull over on my 1.5-hour commute to work because my migraines were so bad I could not drive. My work suffers. I have had 7 days off due to headaches and migraines since January 1st, 2018, after particularly bad odor nights and days. It'll only be a matter of time before I can no longer work. Before moving to our home in Norfolk County, and living next to a marijuana supergrower, I had 5 migraines a year. I haven't had to fill a migraine prescription since 2010, and now migraines plague me on a weekly basis, and my bad days are quickly outnumbering my days without a headache or a migraine. It does not matter the time of year, windows open, windows close, air conditioner on or off, the smell is the same, horrendous. Nothing helps, and trust me, we have tried everything to stay in our home. We even installed a $1,500 air filtration system that attaches to our furnace, and it only helps to mitigate the smell a tiny bit. We can't go outside. During the cycles when harvesting begins, it is like being hit by a wall of stench. It's nauseating. We can barely stand to walk our dog, let alone play outside on our beautiful country property with our own young children. To be a prisoner inside and outside of our home is utterly devastating. We have a 3-acre property, and when we decided to move back to Norfolk, we saved for years to buy an outdoor play structure for our children. It is still in a box, stored away, because we can't bear to set it up in a yard season after season to see it unenjoyed. My children cannot go outside. No one should ever have to hear their 4-year-old tell them, "Mommy, we can't play outside today because it's too stinky." A 4-year-old. Living next to a designated supergrower has taken a mental toll as well. I have had to go on anti-anxiety medication as a result of the constant stress of living beside our neighbors. Living next to the stench has triggered anxiety attacks when the smell starts creeping into our home. as there is nothing I can do to protect my children from feeling sick due to the odor coming from our home from our neighbor's property. Interestingly enough, I could probably get a prescription for marijuana now to help with my migraines and for my anxiety disorder. But, as you well imagine, I cannot do that. Sleep deprivation is another thing that affects not only me, but my entire children, including my 4- and 2-year-old. They recently put in 800 amp service in the last month, so you can imagine how they're gearing up production for spring and summer. So my daughter, you can tell the smell is increasing, and it's getting close to the point where we're going to probably have to evacuate again, as my daughter nightly now has been crying and gagging in the night again, so that's happening again. We had to set up meetings with my son's junior kindergarten teacher's principal and special education coordinator at school to help my son best deal with the feelings and behaviors that go along with living next to a marijuana production facility for a 3-year-old. He was inconsolable each time we had to move out, and my memories of standing at the driveway waiting for the bus for the first day of junior kindergarten are forever shrouded by memories of the smell, the worry that he is going to smell like marijuana, and that CAS will be called. It is not fair that a greenhouse full of marijuana should cause so much confusion and stress for a child. I will stress again that this has nothing to do with being against marijuana. I fully believe that medical marijuana has an important place in society, and we all have people in our lives that are helped or could be helped by it. I held the hand of a dying woman that I would have given anything to if she could live one more day if marijuana would help her. But I know she wouldn't want anyone else to be adversely affected by its growing to make her feel better. What we are asking for is simply zoning regulations and bylaws to protect the people living next to these super growers so that we can enjoy our homes and properties without any adverse physical effects from what our neighbors are producing. The last year living in Norfolk has been the biggest nightmare of my life. But Norfolk County is my home. My family and extended family have been living here and contributing to the community for over 100 years. I don't want to have to sell our house, not that anyone will buy it, because of who and what I live beside. I want my family to live and contribute to Norfolk County for 100 years more, but I can't continue living like this. I need your help to commit to passing and enforcing bylaws and zoning regulations that will help my family and all the other citizens that find themselves living next to a designated supergrower. Please think of my 4- and 2-year-old when you make your decision tonight. My 2-year-old daughter, Emmeline, has lived with these putrid odors in our home for over half her life, and I would love for someone to show me the studies since August 2016 that detail the effects that they do not have on children living next to these 24/7. It's only been happening since August 2016. How can they have studied any children or adults to see how their health is negatively affected living this close to unfiltered thousands and thousands and thousands of plants? Please, please, please help us on behalf of Max, 4-year-old, and Emmeline, 2 years old.
Thank you. Any questions from council members? Thank you, folks. You may be seated. Is there anyone else in attendance who wishes to speak in favor of these amendments? Mr. Rowe, please.
Yes, good evening. I have more of a question for staff in terms of the bylaw itself. I have a client to whom we located in the industrial zone in Simcoe here, and we did a number of years ago got a site-specific relief from the setback, and we have a site-specific bylaw that I believe gives us a setback of 70 meters from an adjacent residential facility. My question to staff would be, there may in fact be others in the same boat, I don't know, but will those bylaws be superseded by the new bylaw, or will the site-specific amendments that were granted to my client and perhaps to others remain in effect?
Through you, Mr. Mayor, any site-specific zoning provisions in relation to medical marijuana will be in fact upheld. This new bylaw won't affect them.
Yeah, and the reason is that my client has spent a lot of money going through the process, through the licensing process. This is a Schedule 1 facility, and we don't want to see a bylaw pass that would create a problem for them. As far as site plan control, my understanding, especially if you're a Schedule 1, you're required by the federal legislation to have an approved site plan and that type of thing. I would think that the Schedule 2 growers, if they want to establish legal nonconformity, the best thing they could do is notify the county prior to passage of any bylaw to say, number one, we're here, and number two, we need a site plan. That would be, I guess, my advice to them, because otherwise it's quite difficult to establish legal nonconformity if you don't, in fact, have any proof that you were, in fact, operating. I guess that's my question, and I wanted that answered just to confirm that my client and others in that same boat can still function under their site-specific amendment.
Through the mayor, I'll just repeat, any properties that have a site-specific zoning provision, those will remain in place. In reference to other facilities, whether or not they're legal non-conforming, again, it'll be a site-by-site analysis.
Yeah, well, thank you.
Thank you, David. Anyone else present wishes to speak in favor of the amendments? Give us your name, sir.
Good evening. My name is Kirk Farish. I understand tonight is based around the legal aspects of growing marijuana commercially. However, I do have a concern of our own, and this is based around respect of neighbors within urban household or property areas. My wife and I recently moved into a brand new home last year. Excuse me, very nervous. As well as did our next door neighbors whose home is attached to ourselves. Our neighbors, through disrespect but not, feel that they have the right to smoke marijuana all day long, 7 days a week, in an open garage, affecting our property, our value of life, our air quality. And I'm finding that there's zero people around who are willing to address this because it's going to be legal. I think that somebody has to step up, protect the citizens, taxpayers, whatever, and the rights that they have within their own property. I don't know how this can be joined on as and affected by the bylaw. However, if some consideration can be made by council and county officials, I think it is a necessity to protect not just ourselves, but other people within this situation, because it's just going to get worse. We've been told that when it does become legal, our neighbors have advised me that they will take it on their own and feel freely to smoke as much as they want, anywhere they want, regardless of the privacy of our own lives. This, again, affects our grandchildren. Affects us. We can't enjoy our own properties, whether it's sitting out outside on our front porch that we had built so that we can thoroughly enjoy it, watch the day go by, or our backyard that we feel that we have the right to use that without being infringed on by again, punitive and disgusting odors, and should have some source of regulation to rely on to enforce our neighbors to, be more considerate. I do understand it's legal, but, there should be some way of enforcing some protection, I guess you may say again, for ourselves who are non-users and cannot stand this odor. So that's all I have to say. Thank you.
Thank you. Any questions for this gentleman?
Thanks.
Thank you very much, sir. Is there anyone else in attendance this evening wishes to speak in favor of the amendments? Her hand was flailing much more than yours, Chris, so you'll be on deck.
You can go if you want.
Do you want to pull the microphone down and you're speaking in favor of the amendments?
Absolutely. I'm Stacy.
Yes, Stacy.
I do not want to repeat what my friends, my posse, everybody has said. So some of it might cross, and I apologize, but it leads into a question.
Stacy, pull your microphone down just a little bit more, please.
Is that okay?
Yeah, that's
Can you
perfect.
hear me now?
I'd like to hear you.
I stand here today in an effort not to repeat what's already been said. I feel as though it must be made clear that this proposed bylaw and the existing bylaw on cannabis production is not about someone's civil right to grow medical marijuana, nor is it about the recreational marijuana that's coming into effect in July. This is simply about the super grows. Well, I have endured the smell, the noise, the continuous light at our particular greenhouse. I have an overwhelming feeling of doom the last 2 years. I simply concur that the smell is putrid, and I would like to put it into terms you might relate to better. While living in a rural area, I anticipate the smell of fertilizer, manure, pesticides, sprays, etc. However, these smells simply come and they go. They're not on a regular basis. Cannabis, on the other hand, comes and stays, and stays, and stays. I've heard some rumbling that smell can be subjective. I question this. I simply question this because I have never met anyone in my life that enjoys the smell of skunk. If one can imagine the smell of one skunk, multiply that by thousands, and have that odor all year round, you can't escape from it. There has been much more lost here in the last 2 years because of the perpetual smell. The stress of it all is killer. I have to say, it consumes you. You see it in the morning, you breathe it in the morning, it's there morning, noon, and night. Simply saying, gone are the days of hiking your own property, hanging your clothes out on the line, leaving a window open, or even parking your car outside. You can't have your friends and your family over. Gone is your sense of security. Gone are the days of asking your neighbor how the weather is. Now we ask, how bad's the smell today? You're essentially a prisoner. I think that the folks that operate these large grow-ops, not the federally licensed facilities exist, should and need to be held to the same accountability and standards of licensed facilities. And it's my understanding that that's what's trying to be accomplished here. My question to council is simply, if you choose not to proceed or actively enforce the existing cannabis production bylaws and put in place new bylaws to protect the citizens of Norfolk County from living beside or around massive grow-ops that have no regulation, I ask, is Norfolk County prepared to purchase my property at fair market value as it was 2 years ago, because it's essentially worthless now because nobody wants to live next to a potential grow-op? I also ask if Norfolk County is prepared to reduce my property taxes and others of those in this county that live near these facilities. I also would like to know if Norfolk County is prepared to give me a grant of some sort to retrofit my home with some sort of air purification. And I'm